you should have an attorney for any DMV hearing involving alcohol or drugs. Really important. Main reason is that an attorney is, especially an experienced attorney, knows how to handle these, knows the rules, knows what the DMV needs to see in order to set the case aside, in order to keep you from getting suspended. And so it is really, really important to have an attorney. To give you an example, I was recently going back and forth with someone who had a second offense, DUI, and they were still on probation for the first one, and they did not get an attorney on the first one. It was a refusal case. And so DMV just suspended them. I don't even think they did the actual hearing. If they did, they didn't win it because they didn't have an attorney who would give them a chance to win it. And they ended up losing their license for a full year. Second case comes along, and now they're facing a 2-year suspension of no driving because the first one was a refusal case. But basically what happens when you get arrested for a DUI with the DMV hearing, and people are always wondering, should I do this? What should I do? Should I call the attorney first? Should I get the DMV hearing first? I always recommend, if you're within the 10 days of arrest, find your lawyer, find your experienced DUI lawyer in Marin County or whatever county your case is in the San Francisco Bay Area or California, and have that attorney contact DMV to request the hearing. That way they can have a better chance of getting, a hearing officer who, some are more likely than others to not suspend you. And so obviously that's pretty important. Having a better chance from the beginning is often the difference between winning and losing your DMV hearing and your license getting suspended. The hearing is basically in front of an administrative hearing officer. There are certain issues. The burden of proof is different than in court. In court, as we know, the prosecutor's office, the district attorney in Marin County, has to show that you were guilty beyond a reasonable doubt. And at DMV, it's a much lower standard that the hearing officer needs to find, and that's the civil standard. Just the tipping of the scales of 51%, the more likely than not, however you want to put it. It doesn't take very much for them to be able to prove the case against you. However, an experienced DUI attorney who's used to dealing with these cases, with drunk driving cases, who's been doing them for years and who does mainly or nothing but DUI cases, which is the case with my office, it's all I do, is going to give you the best chance of winning your case and avoiding a suspension.